Every single taxpayer nationwide trusts government departments to effectively secure their confidential data. During this specific Senate Finance Committee session, Senator Sheldon Whitehouse boldly confronted Treasury Secretary Scott Bessent regarding 400,000 exposed financial returns alongside a remarkably unusual agreement.
And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all.
That statement establishes the mood for the entire clash. Please remain with us as the inquiries grow sharply focused and hidden facts become visible. Here is the complete proceeding from the beginning.
Thanks very much, Secretary. Welcome. Have you identified any precedent in Treasury or IRS history for the agreement not to audit, investigate, or pursue any tax claims against the Trump family or businesses?
I can't identify any precedent where 400,000 tax returns, including people you just mentioned and all of their employees, were leaked in a violation of one of the most sacred duties of the IRS.
So let me cut to that
privacy,
then.
Senator.
The leak was by a contractor. Can you tell me what contribution is being sought by Treasury or by the IRS for the harm done by the contractor? To a certain extent, your organization and the IRS are the victim of the contractor's malfeasance or negligence. What is being pursued by way of contribution by that contractor?
Well, the ranking member chastised me for cutting the contractor's contracts off, and we have removed their contracts, their ability to do business with Treasury and the IRS.
The legal clash of this proceeding is unfolding immediately. You recently observed Treasury Secretary Bessent detail how the vendor forfeited their federal agreements. Although canceling an external agreement eliminates the provider, it ignores the primary issue regarding whether the department pursued monetary compensation for those 400,000 citizens with heavily compromised private files. Before we proceed to the upcoming segment, press like if you believe ending the partnership was sufficient, or reply below if citizens warrant complete recovery. Observe what unfolds next as Senator Whitehouse aggressively pushes for the agreement conditions. Senator Whitehouse firmly declines to abandon the matter. Pay attention as he pivots directly to the exact parameters of the resolution.
But there is no contribution into this particular case.
Again, Senator, you weren't here earlier, but I'm unable to discuss most of this because of ongoing litigation.
Yeah, I know everybody likes to say that, but the constitutional...
We like to follow the law, Senator.
And the law is that the Congress has constitutional oversight functions that do not disappear simply because there is litigation, however convenient it may be, by way of providing answers. So we have no precedent for it. No contribution is being sought from the contractor at fault. Was there any consideration to the government in return for the benefits of no audit, no investigation, no challenge or pursuit of refunds or other penalties?
Again, Senator, I'm unable to comment because of litigation. Treasury is represented by the Department of Justice in all matters. They act as our attorneys. So I would suggest that you direct your questions to Acting Attorney General Blanche.
Yeah, well, I've had a lot of times people who are before us invite me to ask my questions of somebody who's not before us, but you're the one who is before us. And I think you ought to know if there was any consideration offered or paid in return for that settlement. It's a very simple fact question. Was there or was there not consideration?
Again, there's ongoing litigation, and I suggest that you speak with the Treasury attorneys.
This inquiry is hitting its most critical juncture right now. Secretary Bessent instructed an active American lawmaker to consult with external legal counsel. That deflection dodged a progressively narrow string of questions concerning public benefit. Within contract law, consideration stands as the valuable asset both parties forfeit during a legal resolution. Should the administration promise to skip audits or investigations, what exact benefit did the public gain in return? Senator Whitehouse pursued a straightforward and factual response regarding that matter, which the Secretary refused to deliver. Observe what unfolds momentarily as Senator Whitehouse presents an internal document referenced within federal court litigation.
If this kind of behavior is okay with the chairman, I'll just pursue other questions. But, what goes around comes around in terms of dodging questions.
I believe it's very clear that witnesses of any kind cannot discuss ongoing litigation.
They can certainly discuss a fact that they are aware of. The fact that there is some litigation out there doesn't mean that a witness can't say, yeah, there was no consideration, or yes, there was consideration. Was there a defense analysis memo? It's referenced in the judge's decision in Florida. Was there a defense analysis memo prepared by the IRS? And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all. I've been a lawyer all my life. I have some idea of what is protected when you have a ongoing bit of litigation. Whether this individual has seen an official memo from within his own department is a very simple question to answer. And I think it's completely inappropriate to have this game of dodgem be pursued without any consequences.
Senator Whitehouse emphasized a critical legal distinction, noting that litigation privilege protects courtroom strategy rather than whether an executive examined an internal government file. A federal judge in Florida referenced this specific IRS defense memorandum within a formal ruling, but the Secretary refused to acknowledge having reviewed the paperwork. Observe the upcoming developments as the interrogation shifts toward whether concrete legal damages were ever actually established.
Well, last of all, here's another question. Was there any analysis of what harm befell President Trump from having his taxes released when every president since Nixon released their taxes and he had promised to? Did anybody analyze whether there was actually any harm at all to him in those circumstances?
So there was a crime. President's rights under 6103 of the IRS code was violated, and equally as important, 400,000 taxpayers had that right violated, including every employee of the Trump administration, the housekeepers at Doral, the greenskeepers, the cashiers.
And you're welcome to pursue all of that,
care.
but it doesn't answer the question of whether the president actually suffered harm. And you're not.
Senator Whitehouse posed a straightforward inquiry regarding proven damages, and Secretary Bessent responded by mentioning hospitality employees. Federal regulations mandate that any resolution dismissing tax examinations needs evidence of genuine monetary losses, yet rather than offering a formal review, Bessent highlighted domestic staff and groundskeepers. This reply completely ignored the central issue concerning the lawful basis of the compromise. Broadening the scope to encompass countless additional people deflects scrutiny from the precise statutory rationale demanded for this specific arrangement. By dragging 400,000 victims into the discussion, Bessent underscored a genuine problem where the third-party breach compromised massive numbers of everyday citizens nationwide. However, Senator Whitehouse inquired exclusively about whether the principal entity involved in this resolution endured any quantifiable and tangible harm beyond the standard privacy breach. Lacking official proof of distinct damages, the lawful reasoning for the compromise stays entirely unsupported within the official transcript. This nuance holds significant weight within the American judicial system because regulatory breaches and genuine financial injuries represent two completely separate classifications. Pursuant to Section 7431 of the Federal Revenue Code, an illegal release of financial data allows citizens to file civil lawsuits. though judges investigate whether substantive and real-world detriment occurred. Substantive damages involving measurable economic deficits or distinct corporate setbacks are never presumed by the legal system, since they require definitive proof. Once economic maneuvers have already faced widespread media scrutiny, proving distinct and provable damages turns into an essential judicial benchmark. Whitehouse previously served as a United States attorney and formerly held the position of Attorney General for Rhode Island. Should the Internal Defense Memorandum of the Revenue Agency determine that proven damages were negligible or unconfirmed, the lawful basis for blocking routine evaluations and fines grows highly suspect under national policies. Reviewing the initial moments of this congressional appearance, Secretary Bessent offered a remarkable concession for the official transcript. He publicly acknowledged that he could not locate any past equivalent for this particular style of arrangement. The Treasury Secretary overseeing the Revenue Department, with complete access to its entire historical archive, testified before lawmakers and verified that zero matching settlements exist in the files. Zero previous presidencies have ever created a sweeping deal directing the agency to abandon normal examinations or revenue collection efforts based on the Secretary's personal statements to the panel. Bereft of any historical foundation, the statutory structure guiding the resolution functions entirely beyond conventional bureaucratic frameworks. Although unprecedented situations occasionally forge fresh precedents, this also indicates the arrangement materialized without the customary organizational safeguards utilized during past governmental determinations. During routine legal resolutions involving prominent controversies, the department typically records its legislative logic via strict internal evaluations. Since a federal magistrate down in Florida referenced this exact agency defense file during a formal verdict, the paperwork remains a cemented component of judicial archives. Nevertheless, the director of the department refused to verify if he ever actually read the material. During the entire session, Secretary Bessent leaned on rigid bureaucratic defenses by mentioning active lawsuits surrounding the deal conditions, emphasizing contractor dismissals concerning monetary restitution, and invoking worker confidentiality whenever questioned about precise statutory damages. The lawmakers' caution regarding systemic fallout directly targeted the supervisory responsibilities of the congressional panel. The proceeding finished without additional interruptions from panel executives, placing those unresolved inquiries permanently into the government transcript. Whenever national congressional inquiries abandon critical mysteries on the public log, the ultimate verdict falls upon everyday citizens. Did Senator Whitehouse pose the difficult inquiries that the nation needs answered, or did Secretary Bessent adopt the correct statutory position according to agency regulations? Please share your perspectives down in the discussion area. For transparent and direct reporting on legislative sessions alongside political responsibility, press the thumbs up icon and join the Politics Report audience. We appreciate you watching today.